Welcome to Legal Lines. My name is Tom O'Shea, the host of this program brought to you by the York County Bar Foundation. I have a special guest today, York County's District Attorney, Tom Kearney. Welcome, Tom.
Thank you.
And today's topic is DUI, or otherwise known as driving under the influence. And that leads me to my first question, Tom. What is a DUI?
Well, a DUI obviously is not against the law to drink. But it is against the law to drink when you're incapable of safe driving, and that's the legal standard. There's some assumptions that are made by the legislature, and that is if you have a certain level of alcohol within your blood, that you are incapable of safe driving. So merely meeting these levels would constitute an offense in itself. Not only does it involve alcohol, but it also involves the use of drugs, because they can impair your driving as well.
And when you talk about drugs, you're not necessarily limiting that to illegal drugs, are you?
Not necessarily. What the legislature has instructed us to look for is the substances in your bloodstream, and many legal drugs have substances which could end up in your bloodstream, which may make you impaired. People who read the bottle of the prescription that they have should be aware that many times it'll say don't drive after taking this. There's a reason for that, and that is that it can cause drowsiness or situations which may make you incapable of safe driving.
Okay, now, speaking of the alcohol, you said that there's a limit or a legal standard as to when someone is impaired. What is that standard?
Well, it's a medical question. Technically, it's 0.08% of alcohol within your bloodstream. And there are certain tiers, we call them. If you go from 0.08 to 0.08 to 0.10, that's the first tier. If you get to 0.10 to 0.16, that'll be the second tier, and 1/6 or above is the third tier, or any use of illegal drugs will also put you into the third tier. Likewise, if you refuse to take the blood test that will be offered to you, that'll as well put you in a third tier. And what that means is the sanctions that are imposed upon you are directly related to the amount of substance that you have in your stream.
Okay, now let me, and I know this isn't an exact science, but if I were to translate 0.08 into the number of alcoholic drinks that a person would have to consume, what would that be?
Well, you're right. It's not an exact science. It's affected by such things as when you've last slept. It's affected by what you have in your system by way of food. It's affected by your body weight and type. So you're right, it's not an exact science. I think it's wise to limit yourself to no more than 2 alcoholic beverages at a time.
So the 2-beer rule, is that what
Yes.
you're telling us?
Yeah, I think that would be wise.
But someone as heavy as I am might get away with a third, is that what you're telling me?
I'm not telling you that. I'm saying be cautious, and if you have any doubt, that's why you have a designated driver.
And that's the key. That's the key in all of this.
Exactly. Because
it's not illegal to be above a 0.08. It's only legal to be driving above the 0.0.
Exactly. And the truth is, I don't want to have to pick you up. I've got plenty of work. And the fact that I don't have to pick you up is a wonderful thing. What I don't want you to do is kill somebody else on the highway.
Right, and that's the point that we really have to stress. This is really a very serious problem.
Yes.
It's a serious problem in many, many ways, and obviously the most serious part is where people get killed or badly hurt.
Let me tell you how serious it is. 30% of our caseload is DUI. When you look at the numbers, what that means is we run about between 7,500. This year we're at 8,600 cases a year. So you're probably talking about anywhere between 2,500 and 3,000 DUIs that we catch a year. Now,
That's
if you only
just in
catch,
York County.
It's just in York County, and if you figure we catch 1 in 10, okay, what that means is we are 30,000 people on our highway that are driving while they're impaired, and that's scary.
And I think, correct me if I'm wrong, but this doesn't necessarily mean that just late at night.
No, not at all. Many people will drink at nighttime, go to bed, figure they're okay to go to work in the morning, and go to work and be picked up for DUI and have very high readings because they just feel that they've slept it off and now they're okay to drive when they're really not.
Okay, now let's go through the process. What happens if someone is stopped for DUI?
Well, it depends if it's a first or a second offense. If it's a first offense, the rules of court permit us to catch you. After we take you, we will offer you the opportunity to give your blood. If you refuse to give your blood, you will lose your license for a year. You could win the case, and you would still lose your license for a year simply by refusing to give your blood.
So, just to make that clear, and I've heard this happen to people, that they get stopped for DUI. Mm-hmm. They don't know whether or not they're near or over the legal limit. They choose not to have the test, not to have a breathalyzer, not to submit to any type of test. They automatically lose their license even if they ultimately were found not guilty at a trial.
That is absolutely correct.
Okay, so that, and as I understand it, there's a separate legal standard for having a driver's license, and that is because it's a privilege and not a right.
That's what the legislature has said. Many people think, why are they taking my license away? And the answer is because a license is just that. It's a privilege. Like you get a license to get married because it's a privilege to get married. You have a license to have a dog because it's a privilege to have a dog.
And that privilege can be taken away if you don't follow the rules. And one of the rules is if a police officer has probable cause to suspect you were driving under the influence,
yes,
you have given your consent, basically, by getting a driver's license, that you will submit to the drug or the breathalyzer.
That is exactly right. And if you refuse to give that consent, they'll take away your license. And actually, they'll not only suspend it for the DUI, and interestingly enough, we'll talk about the tiers that we talked about. If you refuse to give your blood, you are automatically placed in that highest tier, and it has a higher loss of license for the DUI itself. Now, you have an opportunity to explain at trial why that you did not wish to give your blood. The things I frequently hear are, I was afraid of needles, or something to that effect. Well, that doesn't buy it. Okay. Juries very rarely accept that excuse.
Okay. So now we were talking about there are different tiers, et cetera, but when someone is stopped for DUI, mm-hmm, and they're asked to submit to the test, there's a distinction between someone who had a prior DUI and someone who is, yes, on a second or subsequent DUI?
Yes, on a first offense, you will be picked up, you will be taken to the hospital you'll be asked to submit to a blood test. If you agree, you will be taken to the hospital where that will occur. You will then be brought back to the station, where they will take some information from you, and you will then have to make the call of shame to your spouse or significant other to come pick you up. Probably about 3 weeks later, after they get the results of the blood test, you will be provided a complaint, which is a formal charge against you, assuming your blood alcohol content exceeds the limit. If you are caught a second time, it's a game changer. We have a program called Target 25 because we know that 25% of first offenders will reoffend. Now you can say that's good or bad news because it says 75% of the people have learned their lesson from the first experience. But those 25% we consider to be an extreme danger to the community. So they are actually taken into custody, and they are taken down to the York County Judicial Center, where they are placed in a holding cell until they can meet with the magistrate. The magistrate will set bail. And through the court direction and through a program that has been instituted, which we have participated in the creation of, you will be, part of your conditions of bail is you will have a monitor placed, and you will pay for this, placed on your ankle, which will tell us if you have consumed alcohol.
So this is as you're waiting the trial?
Yes.
After, what is this, the arraignment?
This is immediately after you are arrested. The judge will say you will wear it's called a scram bracelet. And what happens is it's placed on your leg by probation. And what we're trying to do there, it's usually for 7 or 10 days, depending upon your blood alcohol level. What we're trying to look at is, here is a guy that we're saying to, don't drink. And if you can't resist drinking during that 10-day period when you are being monitored, there is a real problem. And when you violate the terms and conditions of that, because the scram bracelet will register, either disconnect if you try to slip some cardboard or your sock between it, okay, and that's considered a violation if you break the contact. What will happen is you will be brought back before the court, and the court was going to place you in jail because you now present a danger to the society.
When this ankle bracelet is put on someone, do they also have to post bail?
Bail may be required. The conditions of bail are simply to ensure your appearance at trial. They will look at a number of factors there, whether you've appeared before, and anything else, whether you have ties to the community. Are you likely to run? We look at if you live out of state or in state. We look at where you live. We look at the seriousness of the charge. Generally, people who are charged with driving under the influence are given a low or non-existent bail. We call it ROR, or release on recognizance. What it means is you don't have to pay any money, but not always.
Okay. Now, there's a program in place that's called ARD. For, I believe that's for first-time offenders.
Yes, not always. Sometimes there's a recognition that some people have exhibited a problem with alcohol, and they are, it's been, maybe they have something in 1985, okay, and now they've, for whatever reason, a loss of job or divorce or something, they've committed this new offense. Those folks, we're not going to deny ARD to, but generally the program is permitted for first-time offenders of minor criminal offenses, not only DUI, and it says to them, if you apply for, are accepted into, and successfully complete the program, the charges against you are dismissed and your record is expunged.
Now, what does ARD stand for, first of all?
ARD stands for Accelerated Rehabilitative Disposition. Forget that, it's meaningless. What is important is what the program tries to do. It's really a second chance for people that are deemed to be worthy, because in today's society, the obtaining of a criminal record is significant because it is so widely available. It is present on the internet. Anybody can look. And there are many companies that won't even hire you if you have a criminal record, won't even look at your job application. So this is, we recognize this. We want to give people an opportunity. Most people who commit DUIs are not evil people. And it goes across all strata of society. And the goal here is not to punish, although some people we need to, and that's an effective detriment, but the goal is to change behavior. And that's what ARD is designed to do.
Now, ARD, is it discretionary with the district attorney?
Yes. The way it works is an application is filed by a defendant, sometimes through counsel, sometimes independently if the person represents himself. The application, there's a workup done at my office. Everything from criminal history record information is obtained, a recommendation of the police officer or not, a recommendation of my attorney or not. If there's a victim, that is your car is in an accident, that'll be looked at. There are certain things that will automatically disqualify you, like if you have a child 14 years of age or younger, or you hurt somebody with serious bodily injury.
And that's disqualified by the state legislature, correct?
Yes, those are things that I cannot consider. But other than that, then I consider the workup that is given to me, and I've actually developed a point system which is available on my website, which is www.yorkda.com. That's available to anybody, which says how I undergo what my thought process is and how I undergo the consideration for ARD.
So someone might know what their chances are of getting ARD, and also it's a little less arbitrary. Is that fair to say?
Yes, I want to make it available to all defense counsel.
We're running out of time this segment. We will be back. This is Legal Lines. My guest is District Attorney Tom Kearney. Welcome back to Legal Lines. My guest today is York County District Attorney Tom Kearney. Our topic is driving under the influence, or DUI. Welcome back, Tom.
Thank you.
And we were talking right before we left about the ARD program, which, as I understand it, a program where somebody who has committed an offense, whether it be DUI or any other type of criminal offense, where the district attorney has some discretion as to let them go through a program where they do not get a criminal record.
Yes.
Is that correct?
Yes.
Can you tell us a little bit about that program?
Sure. Generally, it consists of community service. It'll consist of payment of the costs of the program, some administrative fees. It'll consist of undergoing an alcohol or evaluation, also something called a CRIN evaluation, which is a state-mandated requirement. You will lose your license for a period of time, but it will be far less than what you would do if you had been convicted. There may be some other components, things like if we need a mental health evaluation or anger management, some other things might be applied as well. But those are the general conditions.
And how long would it take someone to go through the program?
The program will last for a year. Generally, people are expected to be completed after 6 months. And all you need to do then is stay out of trouble for the balance of the program, and then we expunge your record.
Okay. Now, if someone does not get ARD and they are prosecuted and found guilty, or they plead guilty, what are the penalties for DUI?
Well, it's a range of sentences. On a first offense with a low blood alcohol level, you won't go to jail and you won't lose your license, but there are some other components to it, many of the same things that are required through the ARD program. Once you get to the second tier or the third tier, those blood alcohol levels that I spoke out, now you will go to jail and you will lose your license for a period of time, generally a year.
That you would lose your license?
Yes, you will lose your license and you will also go to jail.
How long is the jail sentence typically?
Jail generally is either 48 hours or 72 hours, depending on your blood alcohol. On a second offense, it moves up to, if you're the lowest tier, it'll be 5 days in jail. The second tier is 30 days. Third offense is 90 days.
Okay, and that's not absolute. There might be other factors.
Well, these are minimum sentences that are mandated by the state,
But
so it can go higher than that.
And someone who has another criminal history unrelated to DUI, they might face something.
They might face more severe sanctions because of that criminal history. There's generally significant fines to the tune of $1,000 or so, and there's also loss of license that will run up to 18 months.
And remember, DUI kills. There's a different penalty if somebody dies as a result of the DUI.
Absolutely. There's a mandatory minimum sentence of a homicide by vehicle while driving under the influence requires a mandatory minimum sentence of at least 3 years in jail.
Okay. So it appears that obviously this is a serious problem and the penalties are a deterrent to people drinking before they drive. As you said in the first segment, designated driver is the best way to stay out of this, or simply not drink at all.
The whole thing is designed so that you take your keys and you hand them to your neighbor when you're at or your wife or your husband when you're out at a bar.
Okay, now there is something in York County, and I believe in other counties as well, that's known as DUI treatment court. Can you tell us what that is?
Sure. Many people have a severe alcohol problem. They're alcoholics. And the problem is physiological. The problem is many times mental. They're addictive behaviors. And what the DUI courts are designed to do are to take these people that have severe demonstrated problems, usually second offenders of a high level of blood alcohol or third offenders, and to put them through an intensive program which generally lasts a year or 18 months, which requires weekly meetings with the court and a whole multidisciplinary team that will address the problems which lead this person to their addiction.
Okay, so is this a program that anybody can get into, or how is it determined who gets into this program?
Well, right now there are 150 slots available. We're working to try and get to 450. And what this is going to require, obviously, are more resources. But the program has proven to be successful. As we looked at the recidivism rates, as we looked at the jail days saved, as we looked at the amount of money that is spent, it's been extremely successful and a program we want to expand. People who do commit this offense are not bad people, and generally there's something in their personality that causes them not to be able to resist alcohol. Maybe they're self-medicating. Maybe there are many issues that arise. So you must apply. You must be accepted. Okay, and if you are accepted and we throw these intensive resources at you and you're not successful, there's not too much we can do. Now we have to think about the protection of society. So the goal is to treat those who want to be treated. It's much more difficult to go through drug court than it is simply to plead guilty.
And the program that you go through,
or DUI court,
is typically takes a year?
Well, it'll be a year to 18 months.
A year to 18 months.
There's steps that you need to go through. You meet with a judge weekly. You meet with a team. The judge generally knows what already has met with the team, so knows what issues. If you've lost your job, if you've tested positive for substance, if you've are having family issues, the judge will already know these things. And it's many of these things that cause people to self-medicate. So we need to deal with the issues. Sometimes it's as simple as helping people to get educated and find work. And feel that they're functioning members of society rather than, people who have been unsuccessful. Yeah. And it's giving self-confidence to people. So we work with folks and try and get them out of this cycle of addiction.
Now, if they complete this program, is it count as a criminal record? Or?
Well, the way the program works is if you have a felony charge, it becomes a misdemeanor. And if you have a misdemeanor charge, we dismiss it if you successfully complete the program.
By the way, we talked before when we were talking about penalties, whether it was the second conviction or the first conviction with different penalties being required. If someone qualified and successfully completes the ARD program and then they get arrested again, is that considered a first offense or a second offense?
By statute, it is considered a second offense. Now, you might say, well, how do you know that, Kearney? Because you've got, you've expunged the record.
Right.
Well, the statute permits us, the district attorney's office, to maintain a record, okay? And the way we pick it up is it will show up on your driving record that your license has been suspended as a result of an ARD. It doesn't say what the ARD is. So if you get arrested in Wayne County and they run your driving record, and we all do, okay, they're going to see that you went on ARD in your county, and I'm going to get a call, and you're going to find out whether it's for retail theft or DUI, and it's counted as a second offense. But for the public purpose, the only one that can get your driving record is you. So for criminal history record information, when an employer's looking, they're going to look for your driving record, and not your driving record, your criminal record, and that's what gets expunged.
Okay. Now, you mentioned Wayne County, Pennsylvania as an example. What happens if the offense was in another state?
Well, if it's in another state, we also run rap sheets of we'll run rap sheets on people of the FBI maintains a nationwide database.
So in other words, if someone had a DUI in another state, it will be considered a second offense if it's the first offense
Absolutely.
in Pennsylvania.
People think that we don't, if you get arrested in Alaska, that I'm not going to pick it up. We do.
Okay. All right. The treatment program, you also indicated that there are 150 slots, but many more people apply. Who makes the decision whether they qualify?
Well, the decision is made by a team of people. There are usually people have some background, some medical history. All that's taken a look at. There's a recommendation made by the multidisciplinary team. It comes to our office. We have veto power. And we exercise that veto power when there are conditions of public safety involved. For example, and this is not DUI related, but in a drug court, okay, if we find that there's a gun involved, with the drugs, that may put us, in a veto as to whether or not somebody should get into DUI court. So we look at the protection. Our office looks at the protection of society when we're making that determination.
So is the decision made by the district attorney's office or by the court?
The decision is made by the court to accept someone. If it passes a multidisciplinary team muster, it comes to us. We can nix it, or we pass it on to the court. Okay, you will then appear before the court, at which time you will be formally accepted. Actually, before you do that, what the court will require you to do is attend some meetings of other participants, because they want to make sure you understand what you're getting into and how rigorous this program is. But the court would then accept your plea and admit you into the program, and then you're subject to the requirements. They don't sentence you at the time. They just accept your plea of guilty. And the reason is that if you fail to complete the program, they have the option of saying, okay, you know, we've thrown all these resources at you, you haven't succeeded, you don't care really, and so that means something to whether or not we want you on the street.
So to be accepted into the program, you have to plead guilty to the
Yes.
underlying offense.
Yes.
And if you successfully complete the program, then that offense is downgraded or dropped completely if it was
Yes.
a misdemeanor.
Yes.
Is DUI a misdemeanor?
Yes.
Okay. But I assume, I don't know this, but homicide by vehicle while intoxicated is a felony?
Yes.
Okay, so that would be reduced to a
Misdemeanor.
misdemeanor if that was the case.
Yeah.
Statistics. How many? I think at the beginning of the program you talked about roughly what?
Well,
3,000
it's about
cases?
a third of our caseload are driving while intoxicated, whether it's drugs or alcohol. That's a big quantity. We have a whole team in our office that is dedicated to motor vehicle crimes. What we've seen is, it's interesting, if you go from 2007 to 2011, we've seen a 10% reduction in motor vehicle crashes that are caused by alcohol, because we can take your blood if there's a motor vehicle accident and you're suspected of DUI. What we've seen, however, well, at the same time we've seen that reduction, we've seen an increase in drugs in your system for people of that period. And so what that has caused us to do is to take a serious look at drugs. And that's a dirty little secret of DUI, because a lot of times people who have been using illicit drugs have escaped our net because they blow in a preliminary breath test and we're seeing small amounts. But we can bring, what we have done here in York County is to bring in drug recognition experts. And as a result of that, because of our heavy use of those people, we now have per capita the highest level in the state of people that are being arrested for DUI per 10,000 participants in the state. So we're above Philadelphia, we're above Pittsburgh, and above every other county because of our heavy use of that.
This is driving under the influence, but related to drug use.
Exactly.
And as we said at the beginning of this program, drug use doesn't necessarily mean illegal drugs.
No, as a matter of fact, you look at your bottle of your medication and say, I shouldn't be driving, take it seriously. People combine medications. There are many drugs, I can name them, OxyContin, Zoloft, a lot of these drugs.
And a deadly combination is when you have a little alcohol with your regular prescribed medication.
We see that frequently too.
And that could push somebody into a DUI with one drink because they were taking a medication where they shouldn't drink at all.
That's exactly right.
Okay, so watch what you're using, even if your doctor prescribes it, is the lesson there.
Yes.
And then these people would be treated just like any other DUI case, even on prescription medication, if they're driving when they shouldn't be.
That's exactly right.
All right, we're almost out of time, Tom. Thank you very much for being here on Legal Lines. My name is Tom O'Shea. I'm the host of this program, which is brought to you by the York County Bar Foundation. My guest today was York County District Attorney Tom Kearney. Thank you.